sure, I could guess a mistake could happen, but this seemed well beyond a mistake. It seems like they knew well before anyone got hurt that Flint was going to cause problems with the water system.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
There is a pretty massive update in the Flint Water Crisis case. This is the Eastern District of Michigan, the Southern Division, Judith E. Levy judge. It's important because the cases have been consolidated, so it's all different cases and all different judges, and this is the consolidated cases of Judith E. Levy. In re Flint Water cases, this relates to the particular case of Carthen v. Snyder, the class plaintiff's motion for leave to file an amended complaint. This is a class action lawsuit that is part of the litigation collectively referred to as the Flint Water cases. To those following these cases, the facts are by now well known. Plaintiffs, residents, and property owners in Flint, Michigan were exposed to lead, legionella, and other contaminants within the municipal water supply. They allege that defendants, a collection of government officials and private parties, caused or prolonged this exposure, injuring them and damaging their property. In this opinion and order, the court will address the following: plaintiff's motion for leave to file a fourth amended complaint and defendant's motion to dismiss the entire case. So once again, this is kind of complicated, and we're going to skip some of the complicated stuff. There's a huge procedural history to this case. This is ECF. Take a look at this. This is ECF document number 798. I have never, ever seen one that high. I'm sure that they go higher than that. I just personally have never seen one go that high. And there's this massive table of contents that spans 1.5 pages. So we're going to skip most of the procedural stuff. But what you need to know is that the plaintiffs, the citizens of Flint, or the plaintiffs who are choosing to be part of the class, have alleged lots of different civil rights and other injury claims against various defendants. We're focused on Governor Rick Snyder. We want to know whether Governor Rick Snyder is going to be held liable for his part. It seems like he's guilty of basically extreme negligence in not handling the Flint water problems early enough. And you're going to see evidence in here that he knew about it. And so he's going to be allowed to continue as a defendant in the case, and he's not going to be allowed to dismiss himself out of the case. And that's what we're talking about today. The named defendants can be separated into two groups. First, the government defendants include the state defendants Rick Snyder, the former governor of Michigan, the state of Michigan, Andy Dillon, the state of Michigan, Andy Dillon, the treasurer for state of Michigan, Nick Lyon, and others, Nancy Peeler, et cetera, et cetera, et cetera. And there are more. And the court notes that plaintiffs sue the governor both in his official and his individual capacities. That means if you sue the governor as the governor in his official capacity, then the government is sort of the party that's liable if the governor is liable. Whereas if the governor is liable in his individual capacity, that means his money and his houses and cars and assets are used to pay a judgment. He has to pay it individually, and the government doesn't step in and pay that stuff for him if it's only in his individual capacity. So we're just going to refer to him as the Governor Snyder, and we're not going to differentiate between the two. What follows here is a summary of the facts set forth in the third amended complaint, which we are not going to read. I apologize for this, but this is not a Michael Moore movie, and we are not going to go through the entire history of the Flint Water Crisis. But suffice to say, here it is in all of its glory, laid out in a number of pages, explaining how the Flint Water Crisis happened from the plaintiff's perspective. You can either read all of this off the screen here or find a link to the document. I'll try to remember to put one in the description. But you can see how many pages I chose not to go through here for you. I'm very sorry that we couldn't go through all that for you, but the very basics of the Flint Water Crisis, for anyone who doesn't know, are that the Michigan Department of Environmental Protection or Quality, MDEQ, I think it is, and the governor were all involved in switching the city of Flint from one water source to the Flint River. And the Flint River more or less had contaminants in it that were incompatible with the city's existing water system. And when notified that there were actual existing problems in the system, the governor was very slow to respond. And the slow response caused some, possibly all residents who ever drank tap water, to imbibe, to swallow and put into their bodies contaminants like lead, not in insignificant quantities either, in quantities significant to have already caused damage to children who are developing and already cause lead poisoning in adults. And legionella, which is a virus, and other contaminants. And these things really should have all been taken care of before switching any water supply over. And the Michigan Department of Environmental Protection relied on a loophole in reporting. They claimed that because they were switching water sources, they didn't have to test for 2 years, because the law was written that when switching from an existing system to an existing system, you don't have to test, something like that. No. It was rather they considered the switch to be a new system, which didn't have to be tested because a new system would have previously been tested in manufacturing. But this was an existing system that was being used in a different way. So they got around that, and that was also, or rather we hope that that's going to be ruled to be incorrect. So let's find out where we are here. Flint transitioned to the Flint River on April 25th, 2014, and in the 3 months that followed, members of Governor Snyder's senior legal staff began to discuss the possibility of lead contamination. In March 2015, a Flint resident wrote an open letter to Walling stating that the water is dangerous to our health. Ambrose eventually received the letter, forwarded it to Flint's public relations firm, stating simply, "Welcome to Monday." Civic groups tried to get the government defendants to take the issue seriously. Officials dismissed their concerns as unwarranted. Even as the EPA continued to uncover evidence of lead contamination, and some senior members of Governor Snyder's administration voiced the view that the problem was not being taken seriously, many officials continued to deny that anything was wrong. Instead, they put it down to old-time negative racial experiences. Several officials recommended that more money be spent on public relations to combat the issue rather than looking to resolve the underlying problem. On April 28th, 2015, Governor Snyder received an email from his chief of staff advising him that the water issue in Flint continued to be a danger flag for the administration. Later that summer, the governor's director of urban initiatives discussed with him the growing concerns among Flint residents that they were being exposed to contaminated water. And on September 25th, the governor's chief of staff again emailed the governor to discuss the issue of lead exposure and the potential political implications. In the same communication, the chief of staff opined that the residents of Flint were having their concerns about water quality inappropriately dismissed. The governor received this email almost a week before he publicly acknowledged in October 2015 that Flint's water was contaminated with lead. So it's that October 2015, and it was switched over in April. So that's 6 months of contaminated water that residents drank, and we only got to find out about the contamination because the residents themselves got sick. Following his public acknowledgement of the crisis in October 2015, the governor was told in December that in addition to elevated lead levels, Flint residents were also at risk of legionella exposure. Despite all this knowledge, Governor Snyder did not acknowledge or disclose this risk when he declared a state of emergency on January 5th, 2016. It was not until January 13th that he publicly admitted that Flint's water contained legionella bacteria. He did this while activating the Michigan National Guard to assist the people of Flint. On January 14th, Governor Snyder asked the federal government to issue an emergency declaration. The federal government did so 2 days later. In the aftermath of the crisis, facts about how the MDEQ dealt with the disaster came to light. For example, the MDEQ failed to comply with various rules and regulations. State law requires them to notify the public if a source of water is found to be out of compliance. In August 2014, MDEQ officials discussed whether a Flint boil water advisory was caused by a sampling error in a test or a high fecal coliform result. It was far from certain certain that sampling error was the culprit, and although the MDEQ suspected that the water was contaminated, no one made an effort to investigate the issue or notify the public. Throughout the crisis and its aftermath, the concerns and fears of the people of Flint were not taken seriously. In the opinion of some government officials, residents making noise about civil unrest, violence, Michigan State Police shootings, and an emergency manager were the naysayers. These officials believed that too many of them had their hand out and their voices raised, and caving to their demands was part of the reason that Flint had been placed in receivership twice in the past decade. In the view of these officials, the problem was an entitlement mentality. Ultimately, the task force charged with investigating the causes of the crisis summed it up. Flint residents, who are majority Black or African American and among the most impoverished of any metropolitan area in the United States, did not enjoy the same degree of protection from environmental and health hazards as that provided to other communities. I'm a bit disgusted. Actually, I'm a lot disgusted. People are entitled to clean water. I don't really give any further anythings, YouTube demonetization, about whether someone is poor or rich or can pay for it or not. Water, clean water, we're arguing over whether they're entitled to clean water in view of, quote unquote, these officials. They should be ashamed of themselves and go hide in a closet for the rest of their lives. I really would just like to have I'd like to get all their names out and make sure we just put tracking collars on them. I know I'm being extreme in the opposite, but really, clean water is an entitlement mentality. I'm a bit disgusted. Here, the court has provided a helpful table of the claims. Basically, Governor Snyder is a defendant in all of them. They're arguing bodily integrity, equal protection, conspiracy, civil rights violations, and gross negligence. And you'll see that the court pretty much deals with the bodily integrity and equal protection stuff. And then some of the other stuff's a little bit harder, and the court will dismiss some of that. Under bodily integrity, plaintiffs first seek leave to amend their bodily integrity claim brought under 42 U.S.C. 1983, you know that one, that's the civil rights statute that we always talk about, against Defendant Snyder. So they're going to add or keep or add defendants, Governor Snyder, as a defendant in the case. In their view, newly pleaded allegations establish that the governor was aware of the significant risks posed by the Flint River water as early as April 2015, but he did nothing to inform Flint's residents until the crisis could no longer be denied many months later. Additionally, Governor Snyder not only denied the crisis in the intervening period, but later played down the risks for months after having publicly acknowledged the disaster. Because plaintiffs state a plausible bodily injury claim against Governor Snyder, granting leave to include it would not be futile. The right to bodily integrity is a fundamental interest protected by the Due Process Clause of the 14th Amendment. And although violations of the right to bodily integrity usually arise in the context of a physical punishment, the scope of the right is not limited to that context. For example, the forcible injection of medication into a non-consenting person's body represents a substantial interference with that person's liberty. And compulsory treatment with antipsychotic drugs may also invade a patient's interest in bodily integrity. The key is whether the intrusion is consensual. There is no difference between the forced invasion of a person's body and misleading that person into consuming a substance involuntarily. As such, officials can violate an individual's bodily integrity by introducing life-threatening substances into that person's body without their consent. However, to state a claim, plaintiffs must do more than point to the violation of a protected interest. They must also demonstrate that it was infringed arbitrarily. In some contexts, government action may violate substantive due process without a liberty interest at stake. And with executive action, as here, only the most egregious conduct can be classified as unconstitutionally arbitrary. In legal terms, the conduct must shock the conscience. Whether government action shocks the conscience depends on the situation. Where unforeseen circumstances demand the immediate judgment of an executive official, liability turns on whether the decisions were made maliciously and sadistically for the very purpose of causing harm. But where an executive official has time for deliberation before acting, conduct taken with deliberate indifference to the rights of others shocks the conscience. This case involves the latter of these two situations, and as a result, plaintiffs must demonstrate that 1. Officials knew of facts from which they could infer a substantial risk of serious harm, 2. That they did, in fact, infer it, and 3. That they nonetheless acted with indifference, demonstrating a callous disregard towards the rights of those affected. As a preliminary matter, plaintiffs point to a bodily integrity violation. This is not a case about the right to a contaminant-free environment or clean water. Rather, this case implicates the consumption of life-threatening substances. Indeed, neither side disagrees that lead and legionella are life-threatening, nor that plaintiffs ingested these contaminants and others through the water supply. This intrusion was also involuntary. It was involuntary because defendants hid from plaintiffs that Flint's water contained dangerous levels of lead, and because under state and municipal law, plaintiffs were not permitted to receive water in any other way. Plaintiffs' claim therefore implicates the right to bodily injury. Plaintiffs also plead facts which, when taken as true, show that Governor Snyder was deliberately indifferent. First, plaintiffs plausibly allege that Governor Snyder knew of facts from which he could infer that plaintiffs faced a substantial risk of serious harm. As early as March 2014, members of the governor's administration were warning that transitioning to the Flint River could lead to a disaster. Initial warning signs included an outbreak of Legionnaire's disease in the Flint area, and by October 2014, senior staff, including the governor's chief of staff, were discussing the need to return to DWSD water, I guess that's the Detroit water system, because of a growing awareness that the treated Flint River water did not meet established quality standards. In July 2015, this clamor continued to build when the governor's chief of staff wrote that concerns over lead contamination were being inappropriately dismissed. There was also a public outcry. Concerned religious leaders informed the administration of problems with the Flint River. News articles discussed the lead in Flint's drinking water. General Motors stopped using Flint water because it was corroding machinery. Considering the seriousness of the potential problem, the widespread reports, and the seniority of the government staff involved, it is reasonable to infer from the plaintiff's allegations that Governor Snyder was aware of this information. As a result, the governor possessed sufficient facts from which he could have deduced that plaintiffs faced a substantial risk of serious harm from the Flint River. Second, plaintiffs successfully claim that Governor Snyder did in fact infer that plaintiffs faced such a risk of harm. In January 2015, the governor met with other government officials to discuss the ongoing threat to public health posed by Legionella bacteria in the Flint River water. A couple of months later, the governor and his staff discussed whether to distribute water filters to Flint residents as a form of mitigation against possible contamination. At the same time, the governor's chief of staff informed the governor that the water issue in Flint continued to be a danger flag and was something that needed to be addressed sooner than later. And in the summer, a senior member of the administration spoke with Governor Snyder about the fear that Flint's residents were being exposed to toxic levels of lead through the Flint River water. So when plaintiffs state that by February 2015, the governor was fully aware of a public health threat posed by the water supply in Flint, and that by July 2015, at the very latest, the governor knew that the water supply was contaminated, it is reasonable to infer that the governor knew that Flint residents faced a substantial risk of serious harm emanating from the water. Third, plaintiffs plausibly state that the governor acted indifferently to the risk of harm they faced, demonstrating a callous disregard for their right to bodily integrity. This indifference manifested itself in two ways. Initially, the governor was indifferent because instead of mitigating the risk of harm caused by the contaminated water, he covered it up. In private, he worried about the need to return Flint to DWSD water and the potential political implications of the crisis. But in public, he denied all knowledge despite being aware of the developing crisis. As a result, plaintiffs were lured into a false sense of security. They could have taken protective measures if only they had known what the governor knew. Instead, the governor misled them into assuming that nothing was wrong. Governor Snyder's administration even encouraged them to continue to drink and bathe in the water. Subsequently, the governor continued to show indifference to the risk of harm plaintiffs faced. Even once he acknowledged the crisis, he downplayed the risks that plaintiff faced. By October 2015, the governor had publicly admitted that the water was contaminated and Flint had returned to DWSD water. Yet the governor still waited many months to declare a state of emergency. This was despite local area leaders requesting such a declaration as far back as March 2015. Without a state of emergency, plaintiffs were denied valuable resources that could have helped them abate the harm they were still suffering. It is reasonable to infer that the rationale for the delay was in part because the governor wanted to act as if the issue was resolved. But by downplaying the continuing risk of harm, the governor undermined efforts to enact protective measures. And with his initial form of indifference, this led to plaintiffs involuntarily ingesting lead and other contaminants, violating their bodily integrity. These two ways of showing indifference represent a continuum of actions more powerful when combined than when viewed in isolation. They depict indifference in the form of deception, from the governor's unwillingness to admit the crisis to his downplaying of its severity once it became public knowledge. Viewed as a whole, the allegations plausibly describe conscience-shocking conduct. Governor Snyder's actions were deliberately indifferent and exhibited a callous disregard for the plaintiff's right to bodily integrity. In response, Governor Snyder points out that the new allegations do not indicate that he knew of the risks posed by the Flint River prior to the decision to switch water sources. And because in his view, the right to bodily integrity only limits the state's power to take affirmative action, Governor Snyder argues that what he knew after the switch is irrelevant. Moreover, according to the governor, the Constitution does not guarantee that the state will remedy local water contamination issues. However, the governor misunderstands the nature of plaintiffs' claim. Plaintiffs do not argue that Governor Snyder violated their right to bodily integrity by authorizing the switch to the Flint River, nor do they assert that Governor Snyder should have remediated a polluted water source. Rather, plaintiffs contend that the governor was indifferent to their rights by concealing the risk of harm posed by Flint's contaminated water. Although plaintiffs plausibly plead that Governor Snyder violated their right to bodily integrity, qualified immunity shields public officials from undue interference with their duties and from potentially disabling threats of liability. It provides a protection to government officials who make reasonable yet mistaken decisions that involve open questions of law. But an official cannot avail herself of qualified immunity if the right violated was clearly established at the time of the challenged conduct. If controlling case law or a body of persuasive authority has put the constitutional question beyond debate, government officials are on notice that their conduct must conform to an established legal standard. As the Sixth Circuit recently held, the right to bodily integrity was clearly established at the time of the challenged conduct. Knowing the Flint River was unsafe for public use, failing to take steps to counter its problems, and assuring the public in the meantime that it was safe was conduct that would alert a reasonable person to the likelihood of personal liability. In other words, any reasonable official should have known that contaminating a community through its public water supply with deliberate indifference is a government invasion of the highest magnitude. As a result, the governor is not entitled to qualified immunity. Now, we're going to start skipping ahead a little bit here because the rest of this is basically where the court starts to dismiss the claims. So here, as outlined above, plaintiff's first theory is that the defendants created an interim plan to supply Flint with Flint River water while continuing to provide the remainder of Genesee County with DWSD water. In plaintiff's view, there's no rational basis for this decision. These are keywords in the law. The rational basis is the minimum level of constitutional scrutiny. As long as there is a rational basis for a government decision, it can't be challenged by citizens or by a plaintiff. If the constitutional challenge touches on a particularly substantive right, a civil right or constitutional right, then we can elevate the level of scrutiny. I believe Second Amendment rights get intermediate scrutiny, and then First Amendment rights or Fifth Amendment rights or Fourth Amendment rights all receive the strictest level of scrutiny, where it's much stronger than just rational basis. But here, they only need a rational connection. This is a key word, but this is not a super hard word. Is there any reasonable connection other than an arbitrary pretense or something? So could there have been a good reason not an arbitrary, harmful reason, but a reason for the Flint water supply to be switched. And the court says, even assuming that Flint and the remainder of Genesee County were similarly situated for equal protection purposes, which is what we're talking about here, there are many rational reasons that could justify providing only Flint with Flint River water. Maybe the KWA could not proceed without Flint's participation. Flint's participation was contingent upon the FWTP's ability to process the raw water. One key way defendants could accomplish this was to stop paying for the relatively expensive DWSD water and start taking water from the Flint River. Even plaintiffs allege that this was a critical part of the interim plan. In hindsight, this was a terrible decision. It placed financial interests above the health and safety of Flint's residents. Assuming the allegations are true, defendants harmed plaintiffs in the pursuit of fiscal expedience, but the court cannot consider the wisdom of the decision, and it does not matter that defendants may have had other options available to them. It only matters that there is a rational basis for the decision. As such, plaintiff's first theory fails. And the court's going to go on to dismiss race-based accusations and things. There's a lot here. There's hundreds of pages here, and really I don't expect us to be able to get through all of it. So the conclusion that the court reaches here is that plaintiffs can amend their complaint regarding bodily integrity against Governor Snyder, but the remaining claims are denied. So we're really just proceeding on the bodily injury claims against Governor Snyder. And then the court's going to spend the next 50 pages or so going into further explanation, and I think we're going to stop there. So what do you think of that? Do you think Flint's residents were simply entitled in their feeling that they should have had clean water? And what do you think about the perspective that it's not about whether they have their entitlement to clean water, but rather that the governor knew the water wasn't clean and still didn't tell anybody and still didn't mitigate the problem? I think it's important. It's an important distinction, but I'm still firmly on the side that you don't give people unclean water. Sure, I could guess a mistake could happen, but this seemed well beyond a mistake. It seems like they knew well before anyone got hurt that Flint was going to cause problems with the water system. Let us know what you think in the comments. What that means is that Governor Snyder is a defendant, and Governor Snyder is going to be able to get personally sued, both in his official capacity and in his individual personal capacity. And the case is proceeding. It's not over. The plaintiffs still have to prove their case. But, I mean, the judge is already pretty much in agreement with many of these facts. So now we just have to have more or less the trial. Whether it's a jury trial or bench trial, I'm not sure. It might be summary judgment. We don't know. We'll get back to you on that. But let us know what you think about including Governor Snyder in the Flint Water contamination lawsuit. That is our show, everyone. Thank you very much for joining me today. We will produce these videos into the stories that will drop on YouTube this week. We thank you very much for your support, because YouTube has a habit of regularly demonetizing our videos, and it has cut our production profits by a lot, by over 2/3. And we now have Tactical on staff helping us on the law side and occasionally helping us on the YouTube side. And Brandon is on Lawful Masses staff. He gets paid for editing the videos. And so we have financial obligations every month. Our legal news service that allows us to access these stories and documents and things easily is $1,200 a year, et cetera, et cetera, et cetera. So we have some expenses on our end, and YouTube keeps messing with the demonetization. For example, the Joey Johnson story. We put out 2 videos. One is just an extended version of the other. The extended version is fully monetized and confirmed. The shorter version is fully demonetized and confirmed. That makes no sense. They're both the exact same video. One is just longer. So that makes no sense. Anyway, so support us on sponsus.org/law or patreon.com/ljfrench. Thank you very much to our supporters in the month of July. We have a $500 supporter this month, Joshua Davis from TandaPay. We're going to be doing a video about his social insurance program. It's really interesting. It's based on blockchain technology, and it's really, really interesting, and we're going to try and figure out if there's a way we can get this idea to stick in people's heads. I think that's what he's fighting now, is trying to get the idea, because there's too many complicated things to it. Social insurance, what's that? Blockchain, you're going to add that into it, and now people just put it out of their minds. So Joshua Davis from TandaPay, we thank you for your support, and we're looking forward to doing your video on your social insurance program. Thank you also to the $50 plus supporters: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are also scrolling on the LED panel above me, and all of you will be in the description of the videos below. I am Leonard French. I am your favorite copyright attorney, and I will leave some room here for super slow-mo dog video and any other dog video that we've got here, because we shot, I don't know, an hour's worth of dog pool party video between regular slow-mo, like 60 frames per second, and then slowing that down. And then we did some 1080p, I think it was 480 frames per second or 240 frames per second, super slow-mo, and then slowed that down to its 60 frames per second equivalent, and made a whole video for you, and we're going to drop parts of that in the various videos. I think I even dropped some of that today in the video dropped this morning.
Yes,
so,
it is.
Anyway, love you all. See you next time. I'm Leonard French, your favorite copyright attorney. This has been Kaylee here in the studio with us, and Brandon has been in the virtual studio. Thank you all for coming. Love you all, and I'll see you later.